Okay, while surfing the internet, I came across this article titled, "A New California Law Says All Operating Systems, Including Linux, Need to Have Some Form of Age Verification at Account Setup." And alarm bells started ringing because I remember when I was young and my parents bought computers. All we had to do was cut on a computer and start playing solitaire. We didn't have to, you know, log in, type in usernames and passwords just to use a piece of equipment, which what computers are in any type of electronic device. I mean, they're just personal devices that we use in our personal capacities. And so, when I read things like new laws saying operating systems should do such and such and such and such, I just automatically think of more government intrusion. And so let's go down. Let's read some. The government of California is implementing a law that requires operating system providers to implement some form of age verification into their account setup procedures. And so what we can do is we can hover over this with our mouse. We can control click and actually go to the bill. And so I've already read this particular bill, and I actually want everyone who clicks on this video to actually go to this bill, read it, and understand it. And I want you to kind of reconcile with how I described the bill with your own personal experiences with utilizing your electronics in your own homes or in your own businesses or wherever else that you might utilize electronics. My personal opinion is this particular bill is what happens when we combine overachievers, wannabe know-it-alls, and the power of government. And what we get is, a ridiculous piece of legislation that has become law, which, serves no one but the person who wrote it. I guess they get to check a box saying that they got a bill passed, and we get more ways for attorney generals to file bogus lawsuits in court to, I guess, generate settlement monies for themselves. And so let's read some of this introduction. And this introduction is going to be telling. Existing law generally provides protections for minors on the internet. Okay, so right off the bat, they're telling you that existing law does provide protection, including the California Age Appropriation Design Code Act that, among other things, requires a business that provides an online service, product, or feature likely to be accessed by children to do certain things, including estimate the age of child users with a reasonable level of certainty appropriate to the risks that arise from the data management practices of the business, or apply the privacy and data protections afforded to children to all consumers and prohibits an online service, product, or feature from, among other things, using dark patterns to lead or encourage children to provide personal information beyond what is reasonably expected to provide that online service, product, or feature, or to forego privacy protections. This particular introduction is trying to set up the mode or the mood that this new law is legitimate, but it's not. I mean, this first paragraph, it tells you that that businesses do make software that is targeted for children, and that we already have laws that say that those same protections for children should be afforded to everyone else. But again, of course, businesses are going to do everything possible to protect their business. Otherwise, there wouldn't be no business. And for this particular new law to repeat this certain things, I think it's very bogus. Let's see, including estimate the age of child users. I mean, if you know that you're going to be servicing children, I mean, there's no need to estimate the age or verify the age of any user if your particular software or product is targeted for children in the first place. Okay, so let's keep going. This bill, beginning January 1st, 2027, would require, among other things related to age verification, with respect to software applications, an operating system provider as defined to provide an accessible interface at account setup that requires an account holder as defined to indicate the birth, date, age, or both of the user of that device for the purpose of providing a signal regarding the user's age bracket to applications available in the covered application store and to provide a developer as defined who has requested a signal with respect to a particular user with the digital signal via and yada yada yada. All right, so I've read this before and I want you guys to read it and I want you to realize how silly this is. So they're saying that software applications software applications and operating systems must interface with each other, and that's always been the case. Software must interface with the operating system, but now operating systems, must have an interface that requires an account holder to indicate the birth date, age, or both of the user. So what's happening is that they're telling developers that they must make software that asks for the age and birth date of users. But if you read specifically this particular legislation, they're wanting the birth date of children and not the actual account holders or the adults, as I would call them. This bill would prohibit an operating system provider or covered application store from using data collected from a third party in an anti-competitive manner, which is garbage again, but okay. This bill would punish non-compliance with a civil penalty to be enforced by the Attorney General. Again, these new bills, they're being pushed out by these Attorney General to provide them conduits so that they can generate these settlement monies for these bogus lawsuits. And so one of the ways they do this is by saying that there's some sort of threat to child safety. Okay, now the people of the state of California do enact as follows. Section 1, Title 1.81.9 is added to Part 4 of Division 3 of the Civil Code to read Digital Age Assurance Act. Okay, so now let's read these definitions. Account holder means an individual who is at least 18 years of age or a parent or legal guardian of a user who is under 18 years of age. An account holder does not include a parent of an emancipated minor or a parent or legal guardian who is not associated with the user's device. So I want you to stop right there. Just based off these two definitions, we learn of what an account holder is, and we also see that there is a user. And so if those users are under 18, we have to kind of think about or wonder, how do people under 18 years of age come into the possession of, let's say, mobile phones or mobile computing devices? And these mobile computing devices are usually associated with cellular service. How do they afford this cellular service? How do they enter into these contracts if they're under the age of 18 years of age? And so most of the time, parents or legal guardians perform this for children. All right, let's keep reading. Age bracket data means non-personally identifiable data derived from a user's birth date or age for the purpose of sharing with developers of applications that indicates the user's age range, including a minimum the following: whether a user is under 13 years of age, whether the user is at least 13 years of age and under 16 years of age, whether the user is at least 16 years of age and under 18 years of age, and whether the user is at least 18 years of age. Since this is a California law, it makes no sense to kind of partition all these different age brackets. I mean, this particular law covers all of California, and so the only real decision needs to be made is whether that user is 18 or over 18. I mean, these other three is virtually useless. All right, let's keep going. Application means a software application that may be run or directed by a user on a computer, mobile device, or any other general purpose computing device that can access a covered application store or download an application. Okay? Usually, downloads requires broadband internet service. Child means a natural person who is under 18 years of age. So again, they have a definition of child. There's no more need for these four different partitions of people 18 years of age and under. Covered application store, sure. Covered application store does not mean an online service or platform that distributes extensions, plugins, add-ons, sure. Developer means a person that owns, maintains, or controls an application. So again, developer means a person that owns, maintains, or controls an application. So this bill is so stupid. You know, when people download applications, people are now okay, so they might not, so under certain licensing agreement, people may not own it, but they do with their computer devices, they do maintain indirectly those computer applications, and they might even control that application because they control or they should be able to control when that application launches and when it does not launch, which brings up another problem. Are those devices are going to ask every time that that user launches that application, is that user under the age of 18? What about when somebody else wants to borrow or use the particular device for a particular time and launches a particular application? Will that application require age verification over and over again? So this is a problem. Operating system provider means a person or entity that develops, licenses, or controls the operating system. Sure. Signal means age bracket data sent by a real-time secure application programming interface or operating system to an application. So signal means data sent in real time. User means a child that is the primary user of the device. And so here we got this a recursive definition of the word user. User means a user. These people are so, I call them dumb. Okay, now, an operating system provider shall do all of the following. So now the law is forcing operating system providers to, 1, provide an accessible interface at account setup that requires an account holder. Again, account holders are those individuals who is at least 18 years of age or older, to indicate the birth date, age, or both of the user of that device for the purpose of providing a signal. Now this is so stupid. So the particular the particular account holder under the definition of this particular law, and a particular account holder might not have a user because a particular account holder might be 18, might be 19. Let's go back to child. Means a natural person who is under 18 years of age or older. Okay, so yes. So right off the bat, this particular law is absolutely bogus. Provide an accessible interface at account setup that requires an account holder to indicate the birth date, age, or both of the user of that device for the purpose of providing a signal regarding the user's age bracket to applications available in a covered application store. But again, most of us, when we're in the privacy of our own home, it's really not necessary for us to, keep, verify. It's really not necessary to verify our age in the privacy of our own homes. And this is why I say that this particular law is a government overreach. But this particular text is actually bogus because under this text, user means a child that is the primary user of the device. So an account holder might not have or might not be associated with a user under the definitions of this particular law, and still own and possess, mobile, electronic mobile devices. All right, let's keep going. Provide a developer who has requested a signal with respect to a particular user with a digital signal via a reasonably consistent real-time application program interface that identifies those categories of users under the age of 18. But again, let's go back. Um, in the beginning, they talk about managing data and providing protections, but here, in order for the operating system or in order for the interface to actually provide this requested functionality, that interface must verify not only the age of a user under the age of 18, but it also must verify that account holders are also 18 years of age or older. And so how does the particular, where or when does the interface verify that an account holder is 18 years of age or older? So again, this particular text is actually bogus. I mean, if um, if people are knowledgeable enough to utilize electronic electronic equipment, mobile phones, mobile computers, laptops, desktop computers, if we're confident and competent enough to utilize these electronics and the software that comes with them, then um, age verification is intrinsic, meaning that if we're if we're already if we're already competent and knowledgeable of these things, then there's really no need to, perform any other age verification because we know how to use these devices. All right, let's see. A developer shall request a signal with respect to a particular user. Again, does this request happen in the background, or are users and account holders actively communicating with this particular request? Because see, most of the time when we launch our applications, um, the developers are just when developers develop applications, the developers are not really communicating as developers um, to particular users. They're just providing those users, those consumers, with instructions for their particular electronic devices to perform a particular function, or let's say to perform a particular behavior. And most of the time, this behavior is really just showing pictures, images, text on a computer screen. Okay, let's go down. A developer that receives a signal pursuant to this title shall use that signal to comply with applicable law, but shall not do either of the following. Uh, yeah, sure. You all can read this. This particular law is actually forcing developers to create uh, more data, uh, creating a larger surface for manipulation of electronic equipment than is actually necessary. And I think that this particular law does more harm than it actually does good, and it really provides no protection whatsoever, but it does provide a conduit for those attorney generals to recoup monies as penalties in bogus lawsuits. And also I want to concentrate on this last line. The delivery or use of a physical product, um, this title does not apply to. In order for us to download any type of software, um, we have to undergo a physical process. The sending and retrieving of electromagnetic signals is a physical product. that we do pay for with our utility payments for electricity service and broadband service. So I think I've mentioned it earlier, but this last little section, this section F, and particularly section F3, it actually contradicts the whole piece of legislation. All right, so let's go back to this article. There was a particular comment that I wanted to read. Let me scroll down to the comments. There's a lot of comments. All right, it's not age verification and it's not about child safety. It's de-anonymization. The authorities hell-bent on more and more control are seeking to ID the entire internet by any means. I agree. They're going to do it. Thanks for clarifying it. There's no way this will survive the upcoming lawsuit. How in the world do you think collecting in software violates the Fifth Amendment? Well, it does violate the First Amendment because we're in the privacy of our own homes, and you're trying to tell somebody uh, how to communicate with somebody else in the privacy of their own home. So that's a violation. That's none of your business. It's one thing to voluntarily collect identifying information, like it's another thing to forcefully do so under the color of authority. Yeah, this is correct. Oh, this is excessively salty. This one seems like most don't understand the purpose. Let's say you verify that you're of age on your computer, just like how you enter in your birth date on Steam. Now, once you've done that, you no longer have to do that for Discord or any other site that wants to require you to do verification because you've already been verified on your computer. You know, uh, this is a particular functionality or circumstance that might occur and that may be useful for some people, but does that particular circumstance, that functionality, is it necessary to be mandated through the legislators? I don't think so. You don't have to force people to do things like that. But let's say you have a public library and you have so many users and so many child users of a public library and their computer systems available in libraries and computer applications. Now, in order for a particular child user of the or computer and the application, the library is going to have to take in that data and save that data in some database. And when you do that, you increase the attack surface of all this newly created data that's saved in all these personal computers. And so, if we go back to the bill, the purpose of the bill is to, what it says, avoid risks of that arise from data management practices. Now, if we're steadily creating all this data everywhere, like such as in the public libraries, we're creating a larger and larger attack surface for really some unnecessary things, and that's why we have like librarians and so forth to kind of manage the types of applications that go on these computers. And so you really don't need the application developer to do these things. You have um, let's say a librarian to kind of curate which types of software should go on the computers that are can safely serve all the patrons of let's say a public library or any other public space. And so, to put those extra burdens on those software developers and to require that software to, communicate all this extra data, I think it does more harm than good. All right, so if you've clicked on this video, I want you to hit the thumbs up or hit the like button. And please, if you can, leave me a comment down in the comment section for me. And thank you.